Hey everybody, John Skiba here from the Consumer Warrior YouTube channel. And in this video, I'm going to share with you the 3 fundamental things you need to know when filing an answer to a debt collection lawsuit. But if this is your first time here to my YouTube channel, or if you've been here 1,000 times, go ahead and click subscribe if you haven't already, because each week I put out new videos that'll help you deal with your serious debt problem. All right, let's talk about drafting the answer to the debt collection lawsuit. If you've recently been served with a complaint and a summons, the next step is you've got to timely file an answer to those allegations that are in the complaint. If you don't, you run the risk of having a default judgment entered against you, where they give them everything they're asking for, and they usually tack on attorney's fees, court costs, and all that kind of stuff. 95% of people nationwide do not file an answer when they get sued by a debt collector. So be part of the 5% here, where you actually file an answer to avoid the default. It opens up a whole other realm of possibilities as far as what you can do to get this thing resolved. So when you're filing the answer, and let's even before that, when you're drafting the answer, when you're putting this thing together, it's important to understand what the document is, the complaint is, and really what your answer needs to be. And I want to provide you with the 3 most common answers to the allegations that you're going to find in a debt collection lawsuit. Now, first of all, what you need to look at the complaint is. The complaint, or in some jurisdictions it's called the petition, it's really just a set of allegations that the plaintiff has against you, the named defendant in it. And in most jurisdictions, they require each of those allegations to be in numbered paragraphs. So usually you'll see at the top of the document the caption, and then it will go right into the numbered paragraphs where they have their allegations against you, the defendant. Now, what the court wants to know, they want to know, is there actually a dispute here? Do you agree or disagree with what it is that the debt collector is stating against you? Now, from the outset, it's also important to understand you need to be truthful in your responses. You can't just deny things because it may not be financially good for your position, or it may harm your position down the road, but it's important to be extremely precise. And let me show you what I mean by that. The 3 most common answers in responding to allegations in a numbered paragraph in a complaint are that you admit the allegations that are contained in the paragraph, you deny the allegations that are contained in the paragraph, or that you lack sufficient information and therefore you deny at this point. So essentially you're saying either yes, no, or I don't know to each of those numbered paragraphs. And so a typical answer looks like this. In response to paragraph 1, the defendant admits the allegations contained in paragraph 1. Or in response to paragraph number 1, the defendant denies the allegations that are contained therein. Or the third option would be in response to paragraph number 1, the defendant lacks sufficient information to either admit or deny, and therefore denies the allegations contained therein. That's kind of the I don't know option, at least at this point. So when you're going through there, it's important to understand and look, if there are things that you admit. If they're asking you, do you admit that you opened up this particular credit card with this account number? If that's true, you need to admit that. However, if they ask you to admit that you opened some generic credit card or some generic Citibank card and they don't provide the information, it's okay to deny it or qualify it and saying, I may have had a Citibank card, but I deny the remaining allegations therein. They've got to be very specific. This is particularly true with junk debt buyers. Junk debt buyers will often put into the complaint that the debt was transferred to them, or sometimes they'll call it assigned. It was assigned to them. Unless you know for a fact that it was actually transferred or assigned, that your specific account was, you can deny that allegation, or at a minimum say that you don't have sufficient information to admit or deny, and therefore you deny the allegations that are contained in that particular paragraph. This is also true as to the dollar amount. Unless you know specifically how they calculated the amount owed, it's often appropriate to say that you lack sufficient information to either admit or deny what it is that they're alleging, and therefore you deny it. So I hope that makes sense. You don't need to overthink it. You don't have to, a lot of people try to treat the answer as kind of their time to tell their side of the story. It's not that. All it is the court wants to know, is there a dispute? Because if the parties agree on everything, then there's no reason the court needs to be involved, and they'll just grant judgment. But the court wants to know on each of those allegations, do you admit, do you deny, or do you lack sufficient information at this point, and therefore you're going to deny it, at least for right now. If you go with those 3 answers, generally that's not going to steer you wrong. Again, you got to be truthful in what it is that you're doing, but also you got to be very exact in how you respond to it. And if there's something that you don't have independent knowledge of, or like with a debt buyer where they're claiming to have signed it or transfer it, unless you know for sure and they provided you documents to support that, it's generally okay to either deny it or to say that you lack sufficient information. Go ahead again and subscribe to my channel. We put out a lot of videos that give you some tips and strategies on how to deal with these debt collection lawsuits, bankruptcy, all those other kind of debt related type things that can help put you on the track, get you a plan, and help moving you forward. Thanks for watching today.